Okay, good morning.
Morning.
Okay, we're here for an argument in the case of Mark versus Florida Birth-Related Neurological Injury Compensation Association and Adventist Health. How do the appellees intend to divide their time as far as counsel's argument?
Your Honor, we've agreed to divide it 10 minutes each.
Okay, and who will go first?
I will, Your Honor.
Okay. All right, see the other members of the panel, Judges Harris and Sasso. I want to advise counsel that this oral argument is being live streamed by YouTube, so the public does have access to it. And counsel for appellant may proceed.
Thank you, Your Honor, and may it please the court. Thank you for allowing us to appear via this medium. I'm George Silva, and I have the privilege of representing the appellant. As a preliminary matter, I'd like to remind the court that the standard of review in this case is de novo, because this is strictly an interpretation of a statute. And I'd also like to remind the court of the unique circumstances associated with the burden of proof in this case. As the court knows, generally speaking, a petitioner or a plaintiff bears the burden of proof in the underlying proceedings. In this case in particular, the petitioner, because they were applying for NICA benefits under protest, and it was NICA seeking affirmative relief that wanted there to be compensability, as well as the intervener, they bore the burden of proof. And so I think it's important to establish that first, the burden of proof, as well as the standard of review.
So going to the standard review, isn't the issue the timing of when the permanent substantial mental and physical impairment occurred?
No, respectfully, Your Honor, the timing is a factual issue which we do not in any way, shape, or form dispute. We believe the administrative law judge got the facts correctly and simply just misinterpreted the law, the statute, and I believe that the court will understand when it allows me, it will understand where the error occurred. And I think it's actually quite simple when the court has the opportunity to read the transcript and the briefs and hear counsel's argument, will understand why exactly it is very understandable why the court erred.
We certainly read the briefs, so why don't you proceed with your argument on why you think it's a de novo or a matter of law?
Well, as an aside, the intervener, Winnie Palmer, agrees that it is de novo. Having said that, this case revolves around 766.302. And the very unique issue of compensability under 766.302 is that for there to be compensability, the claim must meet 10 criteria. And just using common sense, to meet 10 criteria is very difficult, and that's why there are very few claims that are compensable. The 10 criteria are as follows. 1, the infant must be born alive. It must weigh a certain amount. 3, it must suffer from oxygen deprivation or mechanical injury. 4, this injury must occur in the course of labor, very important, being the longest period, generally speaking, delivery or resuscitation in a hospital renders the infant permanently impaired, substantially impaired, mentally impaired, physically impaired, and it has to be by a participating provider. There's 10 criteria.
Mr. Silva, let me get up to one of those other ones you just mentioned. And I understand the intent behind the statute here, but the phrase or the qualifier in a hospital, what does that apply to? Is it just the post-delivery period in a hospital? Is it labor in a hospital? Is it delivery in a hospital? If you read the statute, where they place the term in a hospital, what does that qualify?
All of the events must happen in a hospital. But quite frankly, Your Honor, it's not even relevant to this argument and to the proceedings, but it is very relevant although we don't need to understand why the court made a mistake, but rather that the administrative law judge erred, it is very important to understand how it is that the administrative law judge erred. And it actually revolves around exactly that, Your Honor. So thank you for the question. So in the underlying proceedings, the issue was that the appellant argued that two of the criteria had not been met. The first one is that the overwhelming amount of the oxygen deprivation occurred outside of a hospital. And that in and of itself made it not compensable. But even if you put the in a hospital aside, it still is not compensable based upon all of the unequivocal, resounding testimony of every single expert and the factual findings of the court that this woman was never in labor when the oxygen deprivation occurred. And so, having said that, I'd like to explain briefly a timeline of the events that happened, with 3 times being very important. Miss Mark was at home when, by all accounts, the oxygen deprivation commenced at 3:19 in the morning. Miss Mark arrived at the hospital at 3:53 in the morning. And the third and important interval is Miss Mark delivered her infant son, Ashton Payne, at 4:04 in the morning. And those are the 3 important times. And the court erred because the court made a very bright line distinction between what happened before getting to the hospital and what happened after getting to the hospital. And that was clear error, because that is not where the compensability issue revolves around. The compensability issue revolves around once the child has been rendered permanently and substantially physically and mentally impaired, the clock stops. And did it happen during one of those 3 phases? And
So
that is
you're arguing the timing of when the substantial mental physical impairment occurred.
Actually, I'm not, because the appellant is embracing the court's findings. The lower court made certain findings that we are embracing. What I'm alluding to, Your Honor, is that the court made a distinction between before the hospital and after the hospital events, rather than, this was the error, rather than the court should have made the distinction between pre-delivery and after delivery, regardless of where the delivery occurred, whether it was in an outhouse or in a hospital.
Didn't the
Silva.
court, go ahead, Judge O'Connor.
Mr. Silva, was there any evidence in the record or any finding by the ALJ as to when the delivery started? Because
The delivery commenced at 4:03 a.m. indisputably, and the child was born at 4:04, 1 minute later. All the records are in evidence, and indisputably, as was clear in the lower panel, in the lower court, the incision and the delivery commenced at 4:03 and the child was delivered at 4:04. Even if we use 4 minutes earlier, 4 a.m. for argument's sake, still the child, not timing, by the court's own findings, the child had already been permanently and substantially injured neurologically as defined.
is there a statutory definition for delivery as far as when delivery commences?
There is not, but the earliest we can talk about delivery, the very earliest we can talk about delivery is when the mother gets to the operating room. And again, by statute, as well as by the facts of this case, the very earliest that would be 3:58 in the morning. And still, the claim is not compensable. We submit to your honors that delivery commences when an effort is made to deliver the child, which is you grab a scalpel and you make an incision. But even if we use the moment the mom is placed in the operating room, 358, this claim is not compensable because the court found, and rightfully so, that the appellees did not meet their burden, that this injury occurred after delivery. The court found actually that the injury occurred the moments, quote, the moments the mother arrived at the hospital. And I'd like to just very briefly discuss with Your Honor what the court relied on. The court relied on the 6 experts that were presented, and all 6 of them resoundingly, whether they testified that the neurological injury had already occurred, manifested, and this child had been rendered, that's the operative term, rendered neurologically impaired prior to getting to the hospital or after getting to the hospital. Every single expert testified, and I'd like to quote from Your Honor the same thing, and in particular, the 4 experts of the appellees. Dr. Willis, the OBGYN expert, testified that no way to gauge when exactly Ashton's brain was rendered neurologically impaired, and I quote, and specifically, it was shortly after arrival at the hospital. That was Dr. Willis. Thus, NICA could not meet its burden of compensability because the court correctly found that Michelle Mark was never in labor. And so therefore, if we base the opinion on Dr. Willis's testimony, they cannot meet their burden. Go to the second expert, NICA's pediatric neurology expert, Dr., and I apologize, I don't know how to pronounce her name, Dr. Siga Dorter, testified that the very, and I quote, very, substantial part of Ashton's brain injury occurred in the final couple of minutes just prior to delivery. This is her testimony. The expert that the administrative law judge relied on testified, the pediatric neurologist, who arguably would be the most knowledgeable, testified the final couple of minutes just prior to delivery. Again, in my court, for the claim to be compensable, the oxygen deprivation must occur during labor, delivery, or post-delivery resuscitation. The expert testified that this in very substantial part of the brain injury occurred in the final couple of minutes just prior to delivery. And the administrative law judge, again, repeatedly cited to this. And so therefore, they did not meet their burden. And the lower court judge agreed because, again, the lower court judge distinguished between pre-hospital and post-hospital. The 2 other experts that the court relied on specifically is intervener Winnie Palmer's expert neonatologist, Dr. Noel. And again, Dr. Noel testified that Ashton, and I quote, suffered a profound neurological injury from the time the mother arrived at the hospital. A profound neurological injury from the time the mother arrived at the hospital. That's on page 764 of the record. And he further, more importantly, testified that the more substantial portion, and I quote, of his brain injury that rendered him neurologically impaired occurred after the time Miss Mark presented at the hospital. And then he keeps going. The point is that these 2 experts, and now I'll keep going to the other 2, because resounding and uniform, which almost never happens, there's always debate amongst experts, and every single expert agreed that by 4:04 in the morning, 4:03, or even 3:58 in the morning, before she walked or was pushed into the delivery room, everyone agrees that the damage had already been done. Interveners, OBGYN expert, Dr. Farb, testified that the substantial part of the injury occurred after arrival, which was 3:53 in the morning, to the hospital. And 90% of the injury at least occurred at the time of admission and after to the hospital. 90% of the next one, and more.
This is the expert testimony. I mean, yes, they say after arriving to the hospital, but they also say, the experts also reference, for example, Dr. Noel, during delivery and post-delivery resuscitation, and that's reflected in the ALJ's findings, where, you know, it says the brain injury endured over the period of time led to this permanent and substantial mental impairment, referring to the 6 days following delivery and during delivery. So there is some evidence in the record referencing the injury that occurred during delivery and post-delivery, right?
Thank you, Your Honor. But the analysis per the statute is once the child was rendered, this is like a light switch. And the administrative law judge agreed, this is the key, Your Honor, that this is, I guess, for lack of a better term by analogy, like when the power goes off. When the power goes off and FP&L reinstates our power, we don't go to every single room in the house to see if the power has come back on. We flip one switch. Once that switch of the light goes on, we have power. The inquiry is over. Or like an amputation. If you get an amputation and subsequently, because there's an infection, you need to do a higher up amputation, you're still an amputee. The question is, when was action rendered neurologically impaired? All of these experts said that the light switch, the analysis ends the moment he was rendered neurologically impaired. If not, respectfully, every single case on the planet in Florida that deals with these issues would be compensable. Because if we use that logic, it's simple that every child eventually ends up in a hospital, whether the oxygen deprivation occurred in the hospital or outside of the hospital. Eventually the child ends up intubated. Eventually the child ends up in a neonatal intensive care unit with acidosis and on and on. And there are neurons dying and cell death. That's not the analysis of the statute.
The question,
Mr. Silva, you're
not-
down about 3.5 minutes, but Judge Harris, go ahead.
It's not really the question of when the child becomes neurologically impaired, is it?
It actually is. That's when the analysis ends. And actually, the administrative law judge actually agreed with that. And
Isn't really more the question of when the child becomes permanently and substantially impaired? Not just any impairment, but
undoubtedly, and thank you for that. And I'd like to talk about how this child was at birth.
All right, Mr. Silva, I'm just letting you know about if you want to reserve time for rebuttal.
3 minutes.
Okay.
Thank you, Your Honors.
All right. Mr. Black.
Yes, good morning. Thank you, Your Honor. May it please the court, David Black on behalf of NICA, the Florida Birth-Related Neurological Injury Compensation Association. I think this is a clear-cut case where you have a situation in which the ALJ had a very complex medical situation with a lot of complex medical facts, and you had 6 different experts that came in and provided testimony. And then the ALJ went through those medical facts, parsed through them, and wrote a very detailed, very analytical order in which he reached his conclusions.
Mr. Black, let me ask you, how would you frame the factual issue before the ALJ, given his finding that the child was not, or the mother was not in labor? So we're just talking about delivery or post-delivery. How would you define the factual issue before the ALJ?
Well, the issue of delivery, as you mentioned, is not defined in the statute, but the language used in the statute talks about in the course of labor, delivery, or the immediate post-delivery period in the hospital. It talks about
so
in
labor's
the course
gone
of.
because labor's gone based on the ALJ's finding and the lack of a cross appeal on that point. So what would be the issue on delivery when the child reached a level of substantial impairment, and whether that occurred before the delivery process? Would that be the issue?
Well, The delivery process, the mother was only at the hospital for 11 minutes before the child was born. She went into the operating room within 5 minutes, and so was in the operating room for 6 minutes while they were prepping her, giving her an intravenous, anesthetizing her, and then delivering the child. So it's really
Does the
5
delivery
and 6 minutes.
process include the time from her arrival to the operating room from 3:53 to 3:58?
I think the course of delivery would be from 3:58 through 4:04 while you're in the process of delivering the child.
All right. How many findings of fact did the ALJ make where it used the 3:58 time rather than the 3:53 time?
He references both. He identifies 3:58 as when she arrives in the operating room.
Right, but his various findings on what the doctors testified to, were they based on did he refer to arrival at the hospital, or did he refer to arrival at the arrival to the operating room?
He referred to arrival at the hospital because understanding when coming into this case, and the petitioner's theory has changed, coming into the case, they tried to divide the line at prior to arrival at the hospital versus from the hospital forward, because their theory initially was that the injury occurred during the 34 minutes before. And the ALJ, in contrast, said, look, I find that the injury occurred during the course of delivery and over the course of the 6 days that followed. Remember, the immediate post-delivery period continues until the child is medically stable. That's based on your Orlando Regional Health case and the Supreme Court's adoption of
Did the ALJ make a legal error by referencing the arrival time of the hospital at all rather than the arrival time into the operating room?
No, I don't think he did, Your Honor, because I think what he was doing was going through this very, very precisely and analyzing the various moments in time. Remember, the standard for us is to determine whether a birth-related neurological injury occurred during the course of any of those 3 events. He did not find there to be labor, which we had advocated there was, so it had to occur during the course of delivery or the immediate post-delivery period.
Well, let me ask you this. If the oxygen deprivation was sufficient to cause substantial impairment prior to delivery, would that be a non-compensable situation?
Well, you don't have that in this case.
No, I'm asking you though, if it was sufficient, if there was substantial impairment prior to the commencement of delivery, would that make it non-compensable?
No, because I think the test is whether you have a birth-related neurological injury that occurs, which has the elements of oxygen deprivation during the course of labor, delivery, or immediate post-delivery period in a hospital, and then leads to a permanent substantial mental and physical impairment. That's the standard that he has to find, which he did find occurred. And I think it's well supported, and there is a plethora of competent substantial evidence, because remember, they're trying to hone this court in now on the 11 minutes. And in doing so, of course, with due respect, they misquote the testimonies of Dr. Noel and Dr. Siga Dorter, because they quote part of it, but they leave out the part where both doctors talk about that the injuries occurring not just after arrival at the hospital, not just during the moments of delivery when the child is completely stressed, but that the injury evolves over the course of time during the period afterwards. And there's plenty of testimony to support that, because you have, in contrast to what occurred before, nobody knows the extent of the oxygen deprivation. All the doctors said that, with the one exception of their Dr. Shabani, who felt that there was anoxia, a complete lack of oxygen, which was refuted. Whereas once you get to the hospital, you have scientific tests that tell you how impaired the child was. And you know that because of the arterial blood gas that was taken at 4:40, that there was an acute situation of hypoxic ischemia. That didn't resolve. And then they took in a second arterial blood gas at 5:14, and the child was still severely oxygen deprived. So that continued for at least 70 minutes after birth. And then you had the child on a mechanical ventilator for 6 days. So the ALJ had that entire period of time of 6 days as the testimony evidences that the injury is evolving and the child's continuing to get worse. That we know. What we don't know is the extent of the oxygen deprivation. And as the experts testified, and the judge actually found, if you don't know the extent of the oxygen deprivation, how do you know the extent of the permanent substantial injury before the child ever got to the hospital or was delivered? It would be speculation. So the exact matters that you want this ALJ to determine is exactly what he did. In other words, it's his burden to go through this and parse through the complex medical testimony, which he did. And in fact, he didn't sign the orders presented by any of the three parties. He wrote his own detailed order. And as he goes through it, your question is, does he have enough evidence to find that there was a birth-related injury that occurred during the course of delivery and the immediate post-delivery period, which encompassed through day 7? And the clear answer, the resounding answer to that is yes. It's speculative, and it would have been pure speculation for him to have found that there was competent substantial evidence that this child was completely impaired before it ever got to the hospital. And in
Is
fact,
that the standard,
testimony
Mr. Black? We don't have to find, it doesn't have to be a finding of complete impairment, does there? It's just substantial and permanent.
Correct.
I'm sorry, I couldn't hear the question, Your Honor.
You said that the ALJ did not find complete impairment. Well, that's not the standard, is it? It's just substantial impairment.
Substantial impairment. The standard is permanent and substantial mental and physical impairment.
Okay.
And,
So-
and given the burden of proof, wouldn't it have been incumbent on your client to demonstrate that there was not substantial impairment prior to the statutory time period?
No, that would not be our burden. It's not our burden to prove a negative, as petitioners or the appellants would suggest that we have that burden. That's not the burden. The standard is whether or not you have a qualifying birth-related neurological injury during the relevant time period. And you have a plethora of evidence. You have 4 doctors that all supported that. And by the way, you had 6 experts in this case, 2 of which were the appellant's experts, 2 of which were the hospital's experts. But our experts, when we bring them in, to be quite frank, is we have them evaluate these claims and determine if they think they're compensable or not. And we go with whatever the experts say. So theirs is an independent review. If they had not felt it was compensable, we would have denied the claim. Rather, we accepted the claim based upon their expert testimony, and then you had the hospital's doctors that supported it. So I don't believe, Judge Sasso, it's our burden to disprove a negative. It's our burden and the ALJ's burden to determine, is there evidence to support that a birth-related neurological injury occurred during the relevant time period? And the relevant time period encompasses over the course through the delivery, because he eliminated labor, through day 7. And you had an abundance of evidence that showed what was going on. You had the oxygen deprivation. You had the arterial blood gases that showed severe oxygen deprivation. You had evidence of seizures, which independently caused injury to this child. And so when you get to the end of it, you know, and unfortunately the testimony is this child suffered a severe, permanent, substantial mental and physical impairment. I'm almost out of time, and I'll just finish it. This is a case where you had a complex medical situation, and the standard for this court is, was there competent substantial evidence? You have the entire analysis the ALJ went through in which he found that there was. So
Thank you.
Unless you have
Ms.
questions for me, I would yield.
Okay, thank you. Ms. Berman?
Good morning, Your Honors. May it please the court, Kimberly Berman on behalf of the Applee Winnie Palmer Hospital for Women and Babies. Your Honors, this court should affirm because there was competent substantial evidence that the birth-related neurological injury occurred in the course of delivery and in the course of the resuscitation in the immediate post-delivery period in a hospital. The DCA cannot substitute.
Let me ask you this. If the
Yes.
child had suffered 90% of the ultimate damage prior to delivery and 10% after, would it be your position? And that 10%, would it be your position that it's still compensable under the Act?
Well, in this case, the 90%.
Is it 90? I'm talking about hypothetically.
Hypothetically, if the child, if you could ascertain that the child incurred 90% of the injury prior to arriving at the hospital, prior to going into labor, prior to going into the delivery room to have the delivery, is that what you're asking, Your Honor?
Let's say prior to going into the operating room, that 90% of the damage had been done. Would it be your position that is not compensable as long as there's some percentage that occurred after that time?
Well, I think, Your Honor, if that was the only testimony that there was, 90%.
I'm doing it hypothetically.
I know, exactly, hypothetical, and that's not what happened here, but hypothetically, if that was the only testimony that it was 90% that occurred, and it was very substantial that occurred prior to the time period, then NICA would not cover it because it has to occur in the time period. You have to have the oxygen deprivation and you have to have the substantial and permanent mental and physical injury in the time period. So if you're saying that the 90% occurred outside the time period, but that's not what we have here, Your Honor.
All right,
What
but
we have-
if enough injury had occurred prior to commencement of delivery to cause a significant impairment, a substantial impairment, would that take it out of the statute and be non-compensable?
And is it only occurring during the prior to delivery? So therefore, there's no testimony as far as the post-delivery period, because there's an ongoing, unbroken chain of
Right,
events
well,
that happen.
that's
You
what
have
I'm
to
trying
look
to-
at multiple things.
That's what I'm trying to understand your point. If there's an ongoing injury that starts before delivery and continues after delivery, at what point does it become non-compensable? I mean, what's the test?
The test is, it's a one period. It's when it starts to when it continues. And here it didn't end until 6 days after birth. There was no way to tell exactly when the substantial impairment occurred by moment. The plaintiff is trying to pinpoint a specific moment in time, but that's impossible to do. All the testimony here was that prior to the arrival at the hospital, there was some oxygen deprivation, although not complete oxygen deprivation, because there was the testimony that the baby was not anoxic, the baby was a hypoxic.
Is
There
arrival
was
at the
also
hospital, is arrival at the hospital the time period we should be looking at, or is commencement delivery the time period we should be looking at?
It's the time period of delivery, Your Honor, and the testimony here was the moments prior to birth and delivery. If you look at the testimony from Dr. Siga Dorter, however you say her name, if you look at her testimony and if you look at some of the findings of fact and the conclusions of law, she interchanges delivery and birth. Delivery is not just the 1 minute cut to create the C-section. The C-sections could take a significant amount of
Right,
time.
well, I
but,
understand the doctor's testimony, but the ALJ, like in paragraph 75, it says the preponderance of the evidence and testimony establishes that Ashton suffered neurological injury after Miss Mark was admitted to Winter Park Hospital. I mean, shouldn't have said after delivery commenced? I mean, shouldn't that be the time we look at?
I don't think he was focusing on a specific moment in time. I mean, it was a very emergent procedure. She came into the hospital after the EMS delivered her, and she went straight into the room. There was also a finding that said AP's reversible brain injury occurred during the final minutes prior to his birth at Winter Park Hospital in the hours and days after his delivery. That's on 762 of the record at paragraph 45. Paragraph 80, it says the very, very substantial part of AP's brain injury occurred at Winter Park in the final couple minutes just prior to delivery. Now, delivery in that word appears to have meant the actual cut. And if that is the case, the incision to remove the child, the final couple moments prior to delivery is the period from 3:58 to 4:04 when the baby was in the hospital preparing for the delivery. So it's all part of that period. So the very substantial injury that we have here occurred in the time frame. In any event, what we also have is the second period. We were able to sustain our burden because all the experts agreed, every single one agreed that there was significant impairment and injury that occurred in the immediate post-delivery resuscitation period. The baby was extremely acidotic as soon as he delivered in the moments afterwards. It wasn't until he was on a respirator for 6 days. So a lot of the testimony, a lot of the findings of fact, a lot of the conclusion, it includes both the delivery period, what happened at the delivery, what happened the moments before the delivery, but also what happened during the delivery. This was a traumatic birth. The child was 37 weeks and had experienced some
I understand that, the doctor's testimony of varying. What concerns me is what the ALJ did. For instance, if the child arrived at the hospital 2 hours before delivery, you wouldn't be making the argument that the 2 hours is covered in defining delivery. Would you agree with that?
It depends, Your Honor. If she was in the labor and delivery
Well,
room
but the
waiting for
trial,
her
the ALJ found there's
procedure.
no labor here.
Correct, but
All right.
if she was
So
in,
my concern is the ALJ's constant reference to arrival at the hospital. One, I can't tell where that has any statutory relevance. To me, the statutory relevance is when delivery commenced. And I think there's only one paragraph where the ALJ really refers to that, and that's paragraph 81, where he talks about encircling the period of delivery. So that's my concern. That's what I'm trying to get you to focus on is did the ALJ use the wrong time period, and if not, why not? And if so, does it matter?
okay, Your Honor, that's a bunch of questions. Let me see if I can answer them in the order that you asked them. First, I think you have to look at the entire order as a whole. There are several findings of fact which the plaintiff do not dispute. They admit for purposes of the appeal everything, and we have not cross-appealed the labor finding. You're correct to say that, but so you have to look at all the findings of fact together, as well as every single conclusion of law. This was a 33-page decision with very detailed findings and very detailed conclusions. And a lot of the language is intermingled between delivery and birth and what occurred, arrival at hospital, but it's arrival at hospital, admission. It's not talking about the time she triage went in to get her fill out paperwork. None of that happened. The moment she arrived at the hospital, she rushed straight in. Within four or 5 minutes, she was in the labor delivery room and she was undergoing preparations to have the delivery. So all of that period is part of it, but I don't think it matters, Your Honor, because I think there was significant amount of testimony that the oxygen deprivation and the permanent and substantial injury occurred during the course of the delivery, which was a traumatic, quick emergency delivery to alleviate the problem that occurred outside the home, inside the home, but it was also the period afterwards. So none of the court, the ALJ could have found that there was nothing happened in the delivery. There was no permanent substantial. As long as they found that it occurred afterwards, that it occurred in the immediate post-delivery period, NICA still would apply. And so a lot of the testimony, a lot of the findings of fact, and a lot of the conclusions of law combine the two of those periods because it's an ongoing, uninterrupted, unbroken chain of events that we have here.
You keep referring to the post-delivery 6-day period as the second period. If it's a second period, is it one continuous event or are there two different periods?
No, it's one period. It's the entire time. But I'm saying that you didn't have to, just like there's an or in the statute, it's labor, delivery, or the immediate post. So you could have found any one of those things occurring. Here, the ALJ found that it occurred during delivery and it continued through the immediate post resuscitation period. That was in one time period, a continuous period, unabated, uninterrupted until the child was able to breathe on his own and the respirator was taken off. So we have the entire period here. The ALJ did not err in interpreting the statute. There was competent substantial evidence, and I see my time is up. So I would just urge the court to affirm the sound findings of the ALJ in this case.
Thank you, Ms. Furman. Mr. Silva, you have 2 minutes and 44 seconds for rebuttal.
Thank you, Your Honor. I think the panel has honed in on the issue, and we need not look any further than paragraph 77 of the plain language and findings of the administrative law judge. And I'd like to quote, the more persuasive medical testimony, we're talking about the burden here, the more persuasive medical testimony supports the finding that Ashton suffered the majority of his neurological injury due to oxygen deprivation during the moments, the plain language of moments, during the moments after Miss Mark reached the hospital at 3:53 a.m. and that this very injury progressed thereafter. The key that he recognizes that this very injury already existed the moments after 3:53 a.m. The inquiry ends. The court need not go any further, and Mr. Black and Ms. Berman reluctantly conceded that if these findings of fact are done, specifically, that the die was cast, once the neurological injury occurs, those 6 days is irrelevant. And actually, Mr. Black alluded to the fact that they don't have the burden of proof of proving a negative. Nothing could be further from the truth, because the Bennett decision specifically required NICA, which was not a compensable claim, to prove that the neurological injury did not happen during the first arrest of the child, but days later in a subsequent arrest. So the 6 days of recitation is relevant to these proceedings. Once that light switch goes off, that there is a permanent and substantial neurological injury, the inquiry is over. Did it happen during the statutory period or not? And this court found that it did not. Specifically, the moments. That's it. We don't need to look any further. More importantly, to give further credence to this, the court referenced, very importantly, the condition of Ashton at the time of his birth. So we don't need to talk about resuscitation. The condition at the time of his birth is that he was born with the single worst APGARs conceivable, that he had no swallowing, no sucking, no gag, no respirations whatsoever. He was blue, floppy, and required immediate chest compressions and intubation. The die was cast the moments that she reached the hospital or shortly thereafter, as the court pointed out in paragraph 77. And so we respectfully submit that the court got the facts right and erred in this distinction between pre-hospital versus post-hospital, rather than pre-delivery versus post-delivery. Thank you so much.
All right, thank you all. Very interesting case, good argument. Court will be adjourned.